The late beloved and great Representative John R. Lewis, my hero, my dear friend, my partner in making good trouble, and my honored colleague, shed his blood and almost died defending the right to vote and seeking the right to vote. He often said, as he did in 2013, that the right to vote is the most powerful, nonviolent tool we have in a democracy. I risked my life defending that right. Some died in the struggle. If we are ever to actualize the true meaning of equality, effective measures such as the Voting Rights Act are still a necessary requirement of democracy. The right to vote is the right that guarantees all other rights in our democracy. Unfortunately, the voting rights of African Americans, Latinos, Native Americans, Asian Americans, and other members of racial and language minorities have been threatened and undermined throughout our nation's history. The Voting Rights Act, with an effective preclearance provision, went a long way towards righting that wrong. Sadly, since the Supreme Court's effective neutering of the preclearance provision, voting rights for minorities once again is under sustained assault in many parts of our country. The Act's preclearance provision requiring certain jurisdictions with a history of voting discrimination against racial and language minority groups, predominantly, though not exclusively, in the Deep South, the states of the old Confederacy, to obtain approval of any changes to their voting laws or procedures from the Department of Justice or the U.S. District Court for the District of Columbia before such changes could take effect. There was good reasons for that. History repeats itself often. And unfortunately, in the Deep South, from where I hail, that has gone on pre-Civil War, post-Civil War, pre-turn of the century, post-turn of the century, pre-election of 2020, and post-election of 2020. This mechanism ensures that the new voting rules and practices in jurisdictions with a history of discrimination were fair to all voters. It rightly prevented potentially discriminatory voting practices from taking effect before they could harm minority voters and affect the election. And in this way, preclearance proved to be a significant means of protection for the rights of minority voters and for what America's about, everybody getting a chance to vote. This is why Congress had repeatedly reauthorized the preclearance provision on an overwhelmingly bipartisan basis. Most recently in 2006, when the House passed reauthorization by a vote of 390 to 33, and the Senate by 98 to 0, a time when there were George Bush compassionate Republicans, a result due in no small part to the substantial efforts also of then House Judiciary Committee Chairman James Sensenbrenner and then subcommittee ranking member Jerry Nadler. Unfortunately, the Supreme Court effectively gutted the VRA's preclearance requirement in 2013 in the case of Shelby County of Alabama versus Holder, when it struck down the geographic coverage formula that determined which jurisdictions would be subject to the preclearance requirement. As a result, the preclearance provision remains dormant unless and until Congress adopts a new coverage formula. Last Congress, I chaired 7 hearings of this subcommittee during which we gathered substantial evidence establishing an extensive and detailed record of continued and ongoing voter suppression efforts, particularly by those sub-jurisdictions that were once subject to the preclearance. Old habits don't die easy. Old times there are not forgotten. So the effective absence of preclearance since the Shelby County decision is gone. For example, in the wake of Shelby County, North Carolina passed a sweeping voter suppression law that federal appeals court ultimately held to be unconstitutional, finding that it intentionally, quote, targeted African Americans with almost surgical precision, unquote. Of course, that was after the election, no preclearance, so the damage had been done. We also heard about recent measures to make it difficult or impossible for minority voters to exercise their right to vote. These measures included polling place closures and relocations, the purging of voter rolls that disproportionately target racial and ethnic minority voters, discriminatory photo ID laws, and the restrictions on ex-felon voting, all of which are designed to make it harder for African Americans and other racial and ethnic minorities to vote. And things only seem to have gotten worse in this regard since the 2020 election, when in response to the widespread but baseless claims of voter fraud, the big lie, there was no evidence of widespread voter fraud in the 2020 election. State legislators though, have introduced a slew of measures to curtail access to the ballot with a disproportionate impact on minority voters. Stacey Abrams laid that out clearly and abundantly to Senator Ted Cruz when he asked about, Senator John Kennedy, when he asked about racial effects of the Georgia law. And she went on, and she went on, and she went on until he kind of said, enough, I get it. I don't think he got it. According to the Brennan Center for Justice at New York University Law School, as of a month ago, there was pending legislation in 47 states to restrict voting, and 4 states had already enacted restricted voting laws. These states include Georgia, a state that had been subject to preclearance pre-Shelby County, where it is now a crime to give food or water to someone standing in line waiting to vote. It's outside the 100-foot border, but it makes it a crime to do it within that 100-foot border, to give food or water. Many of these legislative proposals will limit absentee voting and impose stricter voter ID requirements, while others would make voting registration harder, expand voting roll purges, or adopt flawed practices that would risk improper purges, reduce the amount of days for early voting, and cut back on those early voting periods, according to the Brennan Center report. In the absence of an effective preclearance regime, it is unsurprising that discriminatory measures that have and will continue to undermine the voting rights of racial and language minority voters and erode our democracy. The 2020 election was an election which we should be proud of because the output of the voters, the desire to vote, was the greatest ever. This should be hailed as a great victory of democracy, and yet we're looking at it as a failure and trying to retreat. While Section 2 of the Voting Rights Act, which prohibits discrimination in voting, remains in effect, it is by itself less effective, significantly more cumbersome, and often prohibitively expensive way to enforce the act. Most importantly, plaintiffs cannot invoke Section 2 until after an alleged harm has taken place. Requiring discrimination victims to rely solely on such a remedy effectively neuters the act. And even this provision is currently at significant risk in 2 pending cases before the Supreme Court that could result in Section 2 being substantially curtailed or even struck down as unconstitutional. The onus, therefore, is on Congress to create a new coverage formula to restore the Act's most important enforcement mechanism, its preclearance requirement, and to find other ways to strengthen the Act. Nothing less than the fairness and integrity of our democracy is at stake. I thank our witnesses, and I look forward to their testimony, and I now recognize the ranking member of the subcommittee, the gentleman from Louisiana, Mr. Mike Johnson, for his opening statement.